we go. That looks about right. Will you hit the lights for me, please? Nathaniel? Thank you. Okay, so here we are.
Can we all watch the video on the government page?
You guys can watch that later. We're not going to take time to do that right now. Should we have time at the end of class today, maybe I would think about it. But yeah, I posted that for your enjoyment, and that was posted by permission. So yeah, that'll be free later. So we're going to talk chapter 19 here about civil liberties. I like this quote here by, who do you think that is? Benjamin Franklin, very good. Some of you may have a few of those in your wallet. It says, those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety. That's a really important concept to keep in mind and to remember as we think about the responsibility of government and we think about the liberties that we have. Are we willing to just give up our freedoms and our liberties just to be safe? And I think there's a limit to that, especially when we're talking here about essential liberty and temporary safety. And we've got to be cautious about that. And I think some of the times where we have crises or we have controversies, we are too quick to say, well, we need to make a law about that. We need to change the way our country does things. Well, it might just be a quick reaction to a temporary problem. Now, I know that's not always the case, but here we're going to begin talking about unalienable rights. So, where do we find this phrase in the Constitution?
First one.
And where? Not in the preamble. Where will we find it? Nope. 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 It is in the Declaration of Independence.
Good job, Charlie.
It is not in the Constitution. You're right. So why are we talking about this? Well, because the Declaration of Independence provides a foundation for a lot of what is written throughout the Constitution. And so many times when we look at Amendment 1, they are including some of the freedoms invoked in the Declaration of Independence, such as the unalienable rights. And so we begin here talking about what it means to have unalienable rights. It means that it cannot be surrendered to any government. These are rights that are basic freedoms that every human being ought to have, and that our government should never take over or never control. And in the eyes of many of those who broke away from Great Britain, they believed that King George and Parliament had taken away some of those unalienable rights. They had taken those from the people. So many of the state constitutions and the Articles of Confederation began to incorporate some of these unalienable rights for themselves. And they began writing them in and specifying these are some of our unalienable rights. Part of the reason why I had you read the part of the Virginia Constitution was that was the religious right that they included into their Constitution prior to us having the United States Constitution. So this was already starting to become the thought process of many of our founding fathers. And when we get to the writing of the U.S. Constitution, most of the states already had their own version of these are the defined unalienable rights. These cannot be taken away by our government. And so when those are left out of the original Constitution, many states get all upset and say, we need this in here. And those that were writing the Constitution said, well, why? You already have those in your state constitutions. What do you think the fear was? Why did states demand for the federal Constitution to include many of these rights? Why do you think they were afraid? Or what do you think they're afraid of? If the states already had them in their state constitutions, but we are writing a national constitution, and it's left out of the national constitution, what might be the fear? Josh, what do you think? Not sure that would apply here. Well, the federal constitution, the national constitution, was going to override or going to have more power over the state constitutions. So there's a underlying fear here of what? David, what do you think?
That there would be a repeat of the rule under King George III, that they would not be represented and the rights would be neglected.
Okay, you're exactly right. So, what does the supremacy clause in the Constitution tell us? What is the supreme law of the land? It is the U.S. Constitution. So if all these state constitutions, they have laws in there, or they have provisions for unalienable rights, could the federal Constitution override those at some point down the line? Potentially, yes. That is why they were so insistent on including the Bill of Rights. And that is why we did not even get our Constitution through the ratification process before we already had to change it and amend it. And so, within the Bill of Rights, there are two terms that are often used interchangeably, but if we are to look at them closely, they have different meanings, and they are civil rights and civil liberties. No, you've got an appointment. I do have an assignment for the end of the day today, so I will. Why don't you email me so I don't forget, and I'll reply back with what you need to be doing. Okay. All right. So civil rights and civil liberties. Get my place here again. Okay, civil rights. Civil rights requires the government to act to guarantee constitutional principles to all people. So it's the government's responsibility for civil rights to put in place laws or to put in place acts that will guarantee our constitutional protections. And that is guaranteed to all people. That's the idea of civil rights. Civil liberties, on the other hand, is the guaranteed safety of all people and property from the government's control. So civil rights is primarily talking about constitutional protections. So example of this would be that laws cannot discriminate based on your gender or based on your race, skin color, any of that type of thing. That would be an example of civil rights. An example of civil liberties might be the freedom of religion or the freedom of the press. So these are guaranteeing safety, protection from the government's control in civil liberties. Now it's important for us to understand here that rights are relative, they're not absolute. What did you say? I read about that. Excellent. So what does that mean when we say that they are relative, they're not absolute? We read about it and we heard about it, we already know about it. Jake, what do you think that's talking about? Or does it just ring a bell like, oh yeah, I remember that a little bit?
I remember reading.
Okay. We don't really have full understanding yet. So what do you think that means? That rights are relative and not absolute. Daniel, what do you think? I know you weren't volunteering for that when I was volunteering you. Well said. Yeah. That you have rights, but if they begin to intrude on other people or infringe on their rights, then your limit has been reached. And a lot of people fail to understand this. They want to claim I have rights and I can exercise my rights freely because I'm an American and I know the First Amendment. Well, no, you don't. Because you are pushing your limit and you are infringing on other people's rights, and therefore that's not protected under the First Amendment. If we look at the idea of absolute freedom, if we gave everybody the freedom to do whatever they wanted to, and freedom to make choices, freedom to say whatever they wanted to, that leads to anarchy. I think we only need to look at the news and look at some of the riots that we've seen over the last 3 or 4 years in our country that have sprung up to show evidence of this. So, who gets all these rights? Who does this apply to? Does this apply to citizens? Does this apply to adults? Does this apply to voters, taxpayers? Who all has access to these rights? Everyone. Including illegal immigrants? Including the person that is evading his taxes? Yes, absolutely. Now, that person will face penalties should he get caught, but it does apply to everybody. It applies to people that are visiting our country. It applies to both legal and illegal immigrants. Now, it does not necessarily mean that they all enjoy the same privileges, or they enjoy those privileges to the same degree, but they're all protected under our constitutional unalienable rights. So somebody that may be an illegal immigrant, they may not enjoy the same privileges and freedoms to the same extent that you and I would as a law-abiding citizen. Now, I know I'm moving rather quickly through here, so again, I would encourage you to take a look at my slides on Canvas. If you do miss something here, you guys back up and catch those a little bit later. But with individual rights as they're applied to federalism across the national government here, the original intent, when we look at the Bill of Rights, was originally understood to limit only the federal government. The original intent of the Bill of Rights was not to infringe on the states. That's how it was originally drafted and written. However, that has changed. So those Bill of Rights were supposed to be nationally recognized, unalienable rights. And the states were free to act upon those however they desired. And most states already had these within their state constitutions, so that was going to continue. But since, I think it was about 1920, we have had a change in the way we've interpreted Amendment Number 1, and the way that we have, well, I should say all 10 amendments. In 1920, the court has ruled a little bit differently and has interpreted this differently. And they've been applying more of the Bill of Rights through the 14th Amendment. And there's a process here called incorporation that is really important for us to understand. Incorporation relies upon the due process of law that is found here in Amendment 14. I put the quote up there from Amendment 14. It says, "Nor shall any state deprive any person of life, liberty, or property without the due process of law." So they're using that as an argument here to apply many of these fundamental rights to all the states, because states can't deprive anybody of this. And so the Constitution is going to cover everybody in the state. Thought I had another comment I wanted to make regarding incorporation. Can't seem to find it right now. But it's important that we know incorporation is the fact that we are incorporating the Bill of Rights into the 14th Amendment, and therefore the Bill of Rights are being applied through the Supreme Court, through our constitutional law, to all of the states as well. Okay? So I think think we're good there. When it comes to interpretation, some people interpret this idea of the 14th Amendment, the due process of law, in two different ways. Some people will say that it is procedural due process. So when you get arrested or when you have a legal issue, that everybody is guaranteed a due process, that it is more procedural. If you have a trial, you have a chance to mount a defense, you have a right to an attorney, all those things. And so they will say, well, 14th Amendment does not apply here to incorporation of the Bill of Rights. It applies to simply having a fair and planned out trial. That's your due process. On the other side of the argument is substantive due process, down there at the bottom of the slide. And what that is trying to argue is that you cannot be deprived of anything that is part of our essential beliefs as Americans. That if there's any law, any rule that deprives you of your unalienable rights, your American rights, then it is violating the due process of law here in Amendment number 14. And it's a very controversial issue in our courts right now because it's being argued both ways. A lot of people are siding more on the substantive due process and trying to make sure that we are not violating the individual rights of the person. Here's where the Ninth Amendment comes into play. And I'm not going to say a whole lot here about this, but Amendment number 9 deals with the unenumerated rights, where it says here, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. That's a lot of fancy speak for there are rights we're not going to list here. So unenumerated would be a substitute for the word unlisted. You could very easily put unlisted there if you wanted to. And so the Ninth Amendment recognizes there are some rights, there are some rules and laws that are not listed out here. And they're not going to be right here at this point, but they still belong to the people. It's kind of those unwritten rules and laws. Irony is nobody knows what these rules are. Nobody knows what these rights are. They're unlisted, so they're very vague. You can make up one and you can say, well, that should be protected under Amendment number 9. And so up to this point, the Supreme Court has refused to recognize any claims under the Ninth Amendment. So if you are going to try to make an argument and you want to appear before the Supreme Court and you're making your argument based on Amendment 9, at this point they are just not listing any of those because it's so unclear. So many people think that substantive due process in Amendment 14 accomplishes what the Ninth Amendment was supposed to do. You know, I'm not a law expert here, so I couldn't verify and tell you for sure, but that's where a lot of people are getting that from. So let's move on here to freedom of religion.